Good afternoon. Welcome to the Judicial Committee of the Privy Council, where today we are hearing an appeal from the Court of Appeal of Trinidad and Tobago in the matter of Hosein against Ramnarine-Hill. The case concerns allegations of professional misconduct against Mr Hosein, an attorney at law. The Disciplinary Committee of the Law Association of Trinidad and Tobago found the allegations proved. It was alleged that Mr Hosein had prepared or caused to be prepared forged letters purporting to come from an insurance company and had provided them to his client Mrs Ali with the intention of defrauding her. Mr Hosein appealed to the Court of Appeal, which dismissed his appeal. Mr Hosein now appeals as of right to the Judicial Committee of the Privy Council. I'm Lord Lloyd Jones. I'm sitting today with Lord Briggs.
Good afternoon.
Lady Arden.
Good afternoon.
Lord Sales.
Good afternoon.
And Lord Stevens.
Good afternoon.
Mr Hosein is represented by Mr Robert Strang. The respondent, Ms Ramnarine-Hill, an employee of the insurance company, which was the original complainant, or who was the original complainant, is not participating in the appeal. Mr Strang.
Yes, my lord. And if I could just add to what your lordship just said, in the absence of the respondent, we invited the disciplinary committee, whose finding is the subject of the appeal, to consider making submissions to the board, but there's been no reply to that invitation. The first point that we have to deal with today, my lord, is my application to put evidence before the board. Mr Hosein's application is to put before your lordships the letter that he took to the hearing before the disciplinary committee and sought to put in cross-examination to Nazreen Ali. And I'm asking your lordships to accept that in evidence now, so that you can see what the disciplinary committee refused to admit into evidence for the purposes of my argument that the committee was wrong to refuse to admit it. And the relevant evidence for today's purposes is simply Mr Hosein's evidence that this was the letter that he took to the hearing. And that's really all I want to say about it. It's so that the board can see what was refused and have all the information it needs to understand my argument that the committee was wrong to refuse it. Yes, my lady.
We have the affidavit of the 5th of January 2021, which contains a lot of information about this letter.
Well, yes.
I just wanted to ask you, how much of this information did you give to the district discipline committee?
None, my lady. That's the purpose of that extra information is just so that the board can understand what information might have been available to the committee had they inquired into the letter and assessed it, and to also let the board know that not all of that information will be available now. For example, the electronic information about the creation of the letter.
It's not a question of the discipline committee conducting an investigation into the letter. If you were making an application to put this to Miss Ali in her cross-examination, you would have to explain the provenance of the letter and show that it was a satisfactory document, notwithstanding that it hadn't been put before them in the proper format before.
Yes, I understand that, my lady. We don't have a full note of the exchange that took place when the committee refused Mr Ali's attempt to put it in cross-examination. Sorry, Mr Hosein's request to put it in cross-examination to Mrs Ali. But had Mr Hosein's request been properly considered and tested in my submission, these were questions which were capable of answering at the time. Yes, my Lord Stevens.
He had plenty of opportunities to make available this letter in the ordinary way prior to any hearing taking place, and he didn't avail of any of them.
Yes, he did. He did explain. He did explain that he had taken what turned out to be the misguided view that this wasn't the case that had been properly brought against him, and so he hadn't filed a bundle of documents because he, as it were, went all in on his point that the complaint wasn't properly made. That was a mistake, I accept. But that's his explanation.
Lots of tactical decisions are made in litigation, and you have to live with them.
Yes, my lord. Yes. I think we may slightly be getting onto the territory of my submissions on why the committee was wrong to refuse it. But I do make the point. You're absolutely right, my lord, that you make tactical decisions in litigation and you have to live with them. But the considerations as to whether you should require somebody to live with a tactical decision or force somebody to live with the consequences of a procedural misstep may be different, I submit, in disciplinary proceedings than in ordinary civil litigation. That's one of the arguments I make in this appeal about the disciplinary committee's decision to refuse to admit this letter.
Mr. Strang, this was a document that clearly could have been produced to the tribunal if Mr. Hosein had complied with the directions of the tribunal.
Yes, that's right, my lord. Yes, I accept that. I accept he made a decision not to, and it was on the basis of an approach which failed. But when it came then to hearing the case and hearing what Mr. Hosein had to say, this letter was a very important element of his case, and it was highly material in my submission to the committee's decision about who was telling the truth. And that's why I say they were wrong. The committee was wrong to refuse to put it in, to admit it into evidence.
When the matter went to the Court of Appeal, this point wasn't taken at all, was it?
It was, well, it was anticipated in a ground of appeal, yes, but it was not advanced in argument by Mr. Hosein, the appellant. That ground, what was that? This brings me on to another preliminary point that I have to bring to the attention of the board, is that this morning we filed with the registry a copy of both parties' written submissions to the Court of Appeal. These weren't in the record, and it was due to a misunderstanding on our part, our belief that there had been no exchange of written submissions, no filing of written submissions before the Court of Appeal. We discovered yesterday that their written submissions had been filed, and we received them yesterday evening and filed them this morning. I understand from my Lord Lloyd Jones in conversation just before the hearing that those written submissions have not been circulated, have not been received, at least by my Lord Lloyd Jones. But I will get onto those in my submissions about the main point. But for the purposes of answering my Lord Briggs's question, this point was not argued by Mr. Hosein in the Court of Appeal. No, he did have a ground of appeal that said that argued that the disciplinary committee was wrong to refuse to extend time for the filing of his bundle of documents, which was the basis on which they refused the letter. He didn't elaborate on that in argument. the ground was answered by the respondent in written submissions. Their answer in summary being the committee couldn't be faulted for refusing Mr Hosein permission to cross-examine on that letter because he hadn't filed the document or disclosed it in good time in accordance with the committee's directions, and that was a deliberate decision on his part. That was the respondent's response to the ground of appeal. But no, it wasn't argued, and that's another matter that I have to address in my submissions on this appeal.
All right. Well, is there anything else you want to say on the question as to whether we should admit the document at this stage?
No, thank you, my lord.
Thank you. In that case, we'll retire for a moment, and we can do that now. What's adjourned for the moment? The hearing is resumed. Mr Strang, we refuse the application for permission to rely on this document on this appeal, and we will give our reasons in due course.
Thank you, my lord. I'll have to slightly tailor my submissions on the appeal point in that case. I'm still going to argue that the disciplinary committee were wrong to refuse it at the hearing on the 10th of January 2012, but I won't take your lordships to the letter or discuss any of the details in the letter. So I don't need to start with any background summary of the issues in the appeal, thanks to my Lord Jones's opening introduction. Simply to say that the ultimate issue for the disciplinary committee was whether it believed Mr Hosein or his client Nazreen Ali, and the committee believed Nazreen Ali. The Court of Appeal said this was an issue of credibility, and the disciplinary committee was entitled to find that it did. And I accept it is rare for such findings to be disturbed on appeal. I'm asking your lordships to do so in this case because of two errors of law on the part of the disciplinary committee. First, the disciplinary committee reached its finding without considering material evidence in support of Mr Hosein. It wrongly excluded from the evidence a letter which Mr Hosein said was the real letter he had given Nazreen Ali on the 28th of January, and which set out the true settlement figure of $530,000. I say if that letter had been admitted and tested, the result could have been different because it had the potential to exonerate Mr Hosein. And I say the committee's decision not to admit it was not justifiable and was a material error. And my second error arises from the committee's very brief account in its reasons of Mr Hosein's evidence. I say that suggests it didn't take into account important things he had to say in his defence. There's no mention of them in its judgment. And that leads to the conclusion that the committee didn't appreciate all the issues material to its factual determination. It didn't test the evidence of the witnesses by reference to a correct understanding of the issues. And that was an error of law sufficient to set aside the committee's finding of fact. Perhaps it would be helpful just to start by looking at the forgeries themselves and the genuine letters, if I may. So I'd like to go to page 172 of the electronic bundle. this is Guardian's counter-offer letter of the 3rd of December 2010, and this is the genuine letter. Page 172 is the first page. Page 173 sets out the workings behind the offer, and at the bottom of the page, the opening offer of 460,000. Page 175 is the forgery, 175. This is a first letter, first page of the letter, and it's the same as the genuine one. And your lordships will also see that the manuscript just below, without prejudice, that says Mr Hosein was written there by him. So this is the front page. It wasn't in dispute. This is the front page of the letter received by him from the respondent. He received it on the 23rd of December. Over the page is the forged part of the letter, and you can see that the font is clearly different from the first page. And the offer is different at the bottom of the page, 406 instead of 460 odd. And to reach that offer, some of the constituent parts in the workings are different.
The multiplier is different, isn't it? Yes,
and therefore some of the figures, and one of the figures in special damages is different. Special damages are the same, sorry. In any event, the important point is, yes, the offer is different, and some of the workings have been changed to reflect the lower offer. That's the 3rd of December. The second forgery concerns Guardian's improved offer of the 24th of January 2011, and the genuine letter's on page 181. And if we go through, it's 181 to 2, you'll see that it's a 2-page letter offering, at the bottom of the second page, 529,900. For relative understanding, it's about 10, no, more like 8, I think, Trinidad dollars to a pound. So that's the real counter offer. The forgery is page 183, and it's significantly different. It's a 1-pager, and again, it appears the difference. Some of the differences appear to be obvious. The font is obviously different. The offer is 439,000 instead of 529. And you'll see typos, for example, in the first 2 paragraphs of the small written part of the first 2 paragraphs of the letter. It's letter proper. And then there are interesting typos, for example, in the header by claimant. Instead of Nazreen Ali, it's Nazreen AU. That one speculates might be the result of a misread on a scan, for example. And the same at the bottom of the page with the website.
And there's a line under the heading.
Yes, which yes, that's right, my lord. And then the third letter that Nazreen Ali took to the respondent and said was from Mr Hosein is at page 185, and that's what I've been calling the disputed letter. That's her version of a letter from him on the 28th of January 2011. And that asks her to accept 439,000 odd in settlement. And of course, if Mr Hosein wrote this letter to his client, he was misrepresenting the settlement, because on this day, he and the respondent had agreed 535,000. So if he wrote this letter to the respondent, to Nazreen Ali, there could be little doubt he was the forger. Now, Mr Hosein denied writing this letter. He said he'd given Nazreen Ali. Yes, my Lord Stevens.
He eventually denied writing the letter. He gets this letter presumably as soon as the disciplinary proceedings start, and as soon as Ms. Ali complies with, or the complainant complies with the obligation to make available all documents. It would have been abundantly clear to him at that stage that this was a forgery and that he was not guilty of forging it. So why then, subsequently, on the 7th of May 2011, did he say that the committee was entirely right to exclude his version of it?
Well, my Lord is referring to page 89 of the electronic bundle. And this is where Mr Hosein gives his explains his reason, the reason why he didn't submit a bundle of documents. This is the second paragraph there. His reason for this: he didn't submit a bundle of documents as he was required to do, as he felt the wrong complaint was before the court. He maintains this. And my Lord's referred to the next paragraph. The letter I wrote to Nazreen Ali, other than the disputed one, i.e. the letter dated 28th of January 2011, that I wanted to put to Nazreen Ali, but quite rightly not allowed to do so, as I'd not submitted a bundle of documents. Now, there are 2 or 3 points I would make about that. First of all, what Mr Hosein said then in May could make no difference to the decision of the 10th of January. That had been made 2 hearings before, and it was too late to change it now.
It certainly wasn't too late to change it. Every procedural decision made during the course of a trial can be reviewed. So he had this wonderful opportunity to make whatever submissions he wanted to, but he didn't.
Yes, well, I say too late to change it because Nazreen Ali had already been cross-examined, and so had the respondent.
To recall her.
Yes, I accept that. But Mr Hosein would have known by now what the committee's position was on this letter, because it had refused him already at the point when he wished to put it in cross-examination to Nazreen Ali. And the second point I wish to make about this is to put these comments in context. Mr Hosein here is explaining why he didn't propose to give evidence himself. He's saying to the committee, well, the documentary evidence I wanted to put in was this letter. You've refused me permission. Fair enough. I have no evidence to put in. That's the context in which he's saying it. And the third point I would make is, if Mr Hosein makes the error of not asserting at this stage that it was a mistake on the part of the disciplinary committee, I would ask the board to make some allowance for the fact that he's representing himself. He may be an experienced attorney, but he's not experienced in defending himself in disciplinary proceedings. And that's why people are advised not to represent themselves. Lawyers are advised not to represent themselves in disciplinary proceedings. He's here addressing the most senior members of the profession who are going to decide whether he stays in the profession. And it may well be that the conflicting imperatives of wishing to agree with the tribunal, the imperative of showing agreement with one's peers and seniors, conflicted with the imperative of putting his best case. And that may have been an error on his part, but it doesn't, in my submission, prevent me from taking the point now. And it doesn't mean that the committee was right to refuse to put the letter, to refuse to admit the letter in evidence. Returning to the submissions. I was going to take your lordships to where Mr Hosein denied writing this letter of the 28th. He said that he had given Nazreen Ali a letter setting out the real sum of $535,000. At page 64, the first line, that's where he puts it to Nazreen Ali in cross-examination, and that's her answer, the first line. Page 92 is where Mr Hosein says, in chief, this third paragraph, his account of...
Which page, Mr Strain? Sorry.
Page 92.
Thank you.
Third paragraph, that's his account in chief of the letter he said he wrote. And in cross-examination, page 101, it's the third question, and the answer I informed her on 28th January and confirmed it in writing, and he says the same thing in re-examination. I confirmed the figure of 535 by my letter dated 28th January. Now, as we've discussed, Mr Hosein also produced a copy of what he said was the real letter that he'd given to his client on the 28th of January. I say that letter is important. It was highly material to the disciplinary committee's decision-making because it had the potential to exonerate Mr Hosein. But the committee refused to allow him to put it to Nazreen Ali in cross-examination and declined to consider it because he had not filed a bundle of documents on which he intended to rely in accordance with the committee's procedural direction. Now, that decision isn't recorded in the notes of evidence. We've seen it recorded there at page 89 in the oral submissions after the refusal of Mr Hosein's no-case submission. It's also in written submissions. It's recorded in his written submissions at page 23. Second paragraph. And this will have to be for your lordship's notes because the submissions exchanged in the course of appeal haven't yet reached your lordships, but for your notes, it's also confirmed by the respondent's submissions in the Court of Appeal at paragraph 19. Now, I say the decision to exclude the letter was wrong. It wasn't justifiable as a matter of principle, and it was wrong because it was wrong in these circumstances to exclude material evidence which had the potential to exonerate Mr Hosein. The rule regarding lists of documents is Rule 6 of the Disciplinary Proceedings Rules, and that's in the 5th schedule to the Legal Profession Act, which I have at page 453. Just while we're here at this page, I should show your lordships paragraph 9 of the 4th schedule, because the 4th schedule establishes the disciplinary committee and establishes it and describes its constitution. And here at paragraph 9, it makes brief provision for proceedings such as chair and quorum, but it also says at sub paragraph 6, the committee shall have the power to regulate its own proceedings. So that's an important part of the procedural background. Moving on to the 5th schedule, here we are. Over the page at 454, Rule 6 provides for lists of documents in providing for Form 3 and Form 4, which are sent to the applicant and the attorney, respectively, to notify them of a hearing and to ask them to require them to provide lists of the documents on which they propose to rely. And so it's a Form 4 that's sent to the attorney. And yes, it says such lists shall, unless otherwise ordered by the committee, be furnished at least 14 days before the day of the hearing. Now, the Form 4 that was sent to Mr Hosein is at page 8. And that does indeed include the requirement, list of documents 14 days before the hearing, and provision for consequent inspection. That's the original Form 4 notice, but on the 11th of July 2011, at the first hearing of the complaint, when the committee gave leave for the complaint to proceed, the committee directed a later date for filing of bundles. And that appears from the respondent's letter to the committee at page 197. Because this letter files further documents in accordance with the direction given on the 11th of July 2011. And Mr Hosein didn't file a bundle in accordance with that direction. We've seen already his reasons for not doing so, and it was for that reason that the committee later refused him permission to rely on his version of the letter. If I may give your lordships a bit more statutory context for the procedure, if we return to page 454, Rule 14, there's a general power to adjourn. Rule 17, page 455, general power to extend the time for doing anything under these rules. I've already shown your lordships the last part of Schedule 4. Committee has the power to regulate its own proceedings. But I'll take your lordships to the Act proper, and that's page 444. Section 38.2 gives the committee the powers of the High Court to call for evidence, summon witnesses. Section 38.2. So, in my submission, the general scheme of the rules gives the committee a broad discretion over its own procedure and how it deals with evidence. The question is, how should that discretion have been exercised in the present case when Mr Hosein sought to introduce his letter in cross-examination? And I would identify 3 important factors. First, the letter was highly material because it was potentially very important evidence. Second, it could have been introduced without great difficulty and without unfairness. It wouldn't have been difficult for Nazreen Ali to answer questions on it. It would have been possible to introduce the letter in cross-examination on the 10th of January 2012 without unfairness. If the admission of the letter had led to a need for further evidence or further inquiries, the procedural timetable could easily have accommodated that. The next hearing date was the 31st of January, when the respondent gave evidence. That's page 67 for your reference. Then there was a hearing date on the 7th of May 2012 for the ruling on Mr Hosein's no case submission. That's page 88 for your reference. And Mr Hosein didn't give evidence until the 16th of October 2012. That's page 90. So the timetable could have accommodated any consequential evidence or inquiry. And the third factor, I say, is that procedural decisions in disciplinary proceedings engage a different set of principles from ordinary civil proceedings. And I start with the case of Meadow, page 317. Now, your lordships will recall the case. This case concerned the question of whether experts' immunity from suit should be extended to fitness to practice proceedings. And in the course of deciding that it should not, the Court of Appeal made certain statements of principle about the purpose of fitness to practice proceedings and their difference from civil proceedings. And those comments begin at paragraph 28, which is 335 of the electronic bundle, or 480 of the report's pagination. So they begin at paragraph 28. But I would ask your lordships to move on to paragraph 33 at page 337 or 482 B of the report pagination. And it's what the Master of the Rolls said. I should note here that Ms Davis submits that there's no significant difference between FTP proceedings and civil proceedings, so that the substance of the common law immunity from civil suit should apply to FTP proceedings. I recognise that both sets of proceedings may involve a consideration of some of the same issues of fact. I would not, however, accept Ms Davis' submission. And this is the bit that I emphasise. The crucial distinction is that to which I've just referred. In FTP proceedings, the FPP, Fitness to Practice panel, is concerned to protect the public for the future and not to determine the rights and obligations of the parties in the same way as in a civil action. This introduces a further public interest which is not present in the ordinary civil suit. And the point I make is, if there's a public interest in excluding from the profession incompetent or dishonest practitioners, there's also a public interest in making sure that competent and honest practitioners are not unnecessarily or wrongly excluded. In other words, there's a public interest in an accurate decision and not one that's simply fair between, as in civil proceedings, fair between two parties to the proceedings for the determination as between them of their rights and obligations. There's an extra element. And I say procedural decisions should take that into account. And there's an example of that principle in application in a procedural decision in disciplinary proceedings, in the case of Sonny, which is in my supplemental bundle of authorities, page 78. This was an appeal against findings of misconduct made against a pharmacist. And the appellant on appeal wished to rely on an anonymous letter saying that the complainant had made up the allegations against him. And a preliminary issue heard by Mr. Justice Swift was whether to admit that letter, applying the Ladd-Marshall criteria.
This, as I understand it, Mr. Strang, was a letter which was received after the disciplinary proceedings.
Yes, that's right, yes.
So we're going to paragraph?
Paragraph 26, page 85.
Thank you.
Or if you wish to see the background to Mr. Justice Swift's decision, it's paragraph 24.
Yes.
That says at greater length what I've just said. But this is the part that I wish to draw out is at paragraph 26. What Mr. Justice Swift said in deciding to admit the letter and differing from the General Pharmaceutical Council. And I won't read out his discussion of the potential evidential value of the letter. I'm going to go to the second part of the quote, paragraph 6. I do not consider the anonymous letter can be dismissed quite so summarily as the GPC seems to suggest. This is so, in particular, given the public interest at the heart of this type of regulatory disciplinary procedure, i.e., public interest that the profession is regulated fairly, properly, and to the extent possible, accurately. And with that extra public interest consideration in mind, Mr. Justice Swift decided that the Ladd-Marshall criteria were met. So I say...
But it's a very different case, isn't it? Because the letter did not appear to emanate from the respondent to the disciplinary committee, disciplinary proceedings, and it was accepted by the GPHC that the first condition in Ladd-Marshall was made out. But this is a case where the letter was available to your client, and he could give a full explanation as to its provenance without prompting, without investigation.
Yes, I accept it's a different circumstance. Mr Hosein didn't attempt to introduce it at the first possible opportunity, but he did attempt to introduce it at the hearing, not on appeal, but at the hearing, at the point at which it became relevant. But the point I draw from Sonny does not depend on the facts, on the different facts of Sonny. It depends on the principle that Mr. Justice Swift expressed, that when considering a procedural decision in regulatory disciplinary proceedings, he bore in mind the public interest that the profession is regulated fairly, properly, and to the extent possible, accurately. So that, and I say it follows from that the relevance of accurately is that you might end up with a different decision from a decision in civil proceedings when you are concerned to do. Yes, my lady.
No, I wanted you to finish the sentence. You to finish your sentence.
Yes, when you are concerned to do justice between two parties, as between them, and make a decision as between them as to their rights and obligations. In those civil proceedings, I accept it's likely that a tactical decision or a procedural misstep, you might have to live with that. But if there's a public interest in getting it right and being accurate about who's excluded from the profession, you may end up with a different decision.
Yes, I can see that. But if the issue is fairness, the first condition may be an element of fairness. I think it's long being accepted as such. In this case, your client was wishing to cross-examine a witness on a document whose provenance wasn't proved.
Well, yes, indeed, my lady, but it couldn't be proved until he had come to give evidence himself.
Well, he could have put in an affidavit, he could have put in a bundle, and then there could have been inspection and an issue taken.
Indeed, my lady, and that could still have happened. That could still have happened during proceedings after Mr. Hosein introduced it in cross-examination.
Yes, but isn't it possible for the Discipline Committee to say it is not right to put this document to a witness who's never seen it before, ex hypothesi, or may never have seen it before, and expect her to fairly to answer questions on it, when the elementary step of putting in a bundle and explaining the provenance of this document has not been taken even now?
Well, yes, my lady, but it's really what would really be a very simple matter to put it in my submission, to put it to Mrs. Ali. The question was whether she had seen it before or not. She would have readily been able to answer that question if the document had been put to her in cross-examination. And if any time were needed, it could have been afforded to her. But she would, in my submission, readily be able to answer that question.
It appears
it
to
would
me
have been instructive to see her do so. Sorry, my lord.
It appears to me, in addition to the point that my Lady Arden is making, that your client deliberately held it back in his own briefcase until the last possible moment. As soon as he appreciated that he was going to be referring to it in cross-examination, the proper thing to do would have been to make it available at that time, in advance. And so he was manipulating the system as best he could. And faced with that prospect, a decision of the committee to exclude it could hardly be faulted, could it?
Well, my lord, I'm not sure that I can accept that hypothesis.
Well, why didn't he make it available in advance of the day that she was to be cross-examined? He knew that he was going to be turning up on the 10th of January 2012 in order to cross-examine her. 2011, I think it is. but he knew in advance he was going to cross-examine her, and he knew in advance he was going to be referring to this letter, and yet he held it back.
Yes, my lord, and in his on his case and in his defence, he is cross-examining somebody who has deceitfully made up a case against him.
All the more reason to make available the document that establishes his case in advance, so everyone can see it.
Well, that might be one way of looking at it, my lord. I don't accept that it makes it. I don't accept that it makes it. I don't believe it makes it unfair for him to cross-examine Nazreen Ali by producing the document.
But you accept it. You accept as
yes,
I understand it. You accept it's unfair not to make it available in advance.
Well, Nazreen Ali is not the one on trial. She's a witness. Mr Hosein says she was a dishonest witness. He wished to put.
Sorry, I'm sorry. Was it unfair not to make it available in advance?
I'm not sure I accept that it was unfair. Not in the circumstances where Mr Hossein's case is that Nazreen Ali is a dishonest witness who's made up an allegation against him, and he's the one who's on trial.
Mrs. Ali had disclosed although she wasn't a party, the documents had been disclosed by the complainant, hadn't they?
Yes, my lord. Yes.
Yeah. But this was held back.
Yes.
With a view in cross-examination, Mrs. Ali.
Well, I can't answer for Mr. I don't know what Mr. Hossein's decision making. I'm not sure I accept that was his decision making process. He explained his decision to the committee. He hadn't put in a bundle of documents because he intended to have the complaint dismissed in limine.
Yes, thank you.
Thank you, Mr.
Yes,
Lawrence has a question.
Can you just tell me on the chronology? I think you told earlier on that the ruling on whether there was a case to answer was later than this evidence. It was about 4 months later, in May.
Yes.
I know you put it in the chronology, and it may be my fault for not having been through it in sufficient detail, but at what point did your client make his application that the proceedings were misfounded, misconceived, and would be dismissed in limine?
At the leave stage, which was July 2011.
So he'd lost that 6 months previously.
Well, let me. Perhaps I better check that, my lord, because now I'm not entirely sure of the chronology myself. Might need to go to the notes of evidence. Yes, the chronology is at page 219.
Yes,
They grant leave on July 2011, and the next hearing date is 10th of January 2012.
So from July 2011, he knows that his objection that the complainant doesn't have locus has been rejected, and that the case is therefore going to be fought on the merits, and that he won't get another opportunity to say there's no case until after the evidence of the complaint, including for this purpose the evidence of Ms. Ali.
That's right, my lord, yes.
Yes. Thank you.
Moving on with my submissions, I think I had dealt with the public interest point in disciplinary proceedings. And so those three factors that I identified, I say they all argued in favour of admitting the letter. And if the committee had taken them into account, it would have admitted the letter. So, and if the letter had been admitted, testing it at the hearing would have been highly informative. It could have led to a different result. Well, we've discussed this, but first, because the committee would have seen Nazreen Ali cross-examined on it. Second, the letter would have raised many questions for Mr Hosein, and his answers to them would have been instructive in the committee's assessment of his credibility. Those questions include: when was the letter created? Is there electronic data available to show that when it was created? Who typed the letter? And what does the person who typed the letter have to say about the circumstances in which it was created? Answers to all of those questions by Mr Hosein would have been highly instructive on the question of his credibility.
Aren't those features of the case which indicate strongly why it was necessary for there to be disclosure in advance?
My lord, I didn't hear the last part of the question.
Aren't those matters on which you rely, matters which you say might have been investigated at that later stage, are those not features which indicate the importance of providing disclosure in advance?
My lord, they could readily have been dealt with in the procedural timetable that followed, is my answer to that. There were two further hearings. Well, there were, after the refusal of the letter, there were in fact three further hearings. The 31st of January, and then May, and then October 2012. So these matters could have been explored and tested in the proceedings, even with Mr Hosein's late introduction of the letter, without difficulty and without unfairness. And the other way in which admitting the letter in would have been instructive would be in comparing the two versions of the letter and all the other letters produced by Mr Hosein's office, looking at similarities and differences. And the committee could have inquired into those. Yes, my lord.
As I understand the position, there is absolutely no explanation as to why Mr Hosein did not make this document available in advance. We have no evidence whatsoever about that.
Yes, save for what he said to the committee orally at the rejection of his no-case submission. That's right, yes.
Thank you.
Now, so for those reasons, I say the committee should have allowed the letter in. Mr Hosein didn't argue this point concerning the exclusion of the letter in his appeal to the Court of Appeal. And there was a ground of appeal directed towards the point. You can see that at page 107. It's 3F. But Mr Hosein didn't expand on that ground in his written submissions. The respondent did address that ground in her written submissions in his response. And again, for your references, it's paragraphs 17 to 20 of the respondent's written submissions in the Court of Appeal. And she said, in short, the committee couldn't be faulted for not permitting Mr Hosein to put the letter to Nazreen Ali in cross-examination because he hadn't disclosed it in accordance with directions, and it had been a deliberate decision on his part. So Mr Hosein didn't articulate or argue the point I'm making now, and the Court of Appeal didn't rule on it, but I submit that ought not prevent the board entertaining it now, for three reasons. First, this isn't a point, I say, where the board needs the assistance of the Court of Appeal, and in that regard, I refer your lordships to the case of Baker, which I dare say you're familiar with. It's at 255, and the passage on the board's practice on new points is at 269 or 788 of the report. So it halfway down A, its normal practice is not to allow the parties to raise for the first time in an appeal to the board a point of law which has not been argued in the court from which the appeal is brought. Exceptionally, it allows this practice to be departed from if the new point of law sought to be raised is one which in the board's view is incapable of depending upon an appreciation of matters of evidence or of facts of which judicial notice might be taken, and is also one upon which in the board's view they would not derive assistance from learning the opinions of judges of the local courts upon it. So it's not a case where the board will need the assistance of Court of Appeal if the board entertains this point. Second, as I've said before, I would ask the board to make some allowance for the fact that Mr Hosein was representing himself for the reasons I've already given. And third, in my submission, it's in the public interest to ensure that the disciplinary committee has the right guidance on the exercise of its procedural discretion. In my written case, I mentioned Rule 2813 in the Trinidad CPR, and you can see that at page 460. (2813)(1). That's the rule concerning disclosure in the Trinidad CPR. And exclusionary rules like that are not uncommon in the Trinidad CPR. But for the reasons I gave, referring to Meadow and Sonny, in my submission, the disciplinary committee should be, although they be very, no doubt, as experienced attorneys and litigators, very familiar with the provisions of the Trinidad CPR, they should be slow to bring that exclusionary approach into disciplinary proceedings without taking into account the wider public interest that we referred to earlier. So that concludes my arguments on the exclusion of the letter. The second argument that I set out in my written case concerns the scant account in the committee's judgment of what Mr Hosein had to say in his defence. In my written case, I described it as a lack of reasons, but it's not precisely that. The argument isn't that the committee failed to give a reason for its findings. Mr Hosein knows why the committee found against him. It didn't believe him, it believed Nazreen Ali. But the argument's rather that when rejecting Mr Hosein's evidence, the committee gave an account of his evidence which omitted important matters he'd said in his defence. And the inference I asked the board to draw from that is the committee didn't understand the importance of those matters and didn't consider them when making its decision. Now, the committee's account of Mr Hosein's evidence is at page 51, paragraph 18. So there it is. He didn't give her the 3 letters which she said he'd given her. He said he gave her the real version of the letter the 3rd of December and the real version of the letter of the 24th of January. That's the sum of the committee's account of Mr Hosein's evidence in his defence. And I've already mentioned one important omission there, and that's Mr Hosein's account of the true letter of the 20th of January 2011. The other particular matter I would emphasise is what Mr Hosein said about his client's knowledge of Guardian's offer. He said that Nazreen Ali, through her sister-in-law, knew of Guardian's opening offer before he did. And her sister-in-law, Ria Solomon, told him that she had a contact inside Guardian. And you can see how he put the point orally to the committee at page 85. Beginning at the 3rd paragraph. This is when he's making a submission of no case to answer. The 3rd paragraph there refers to some of the respondent's evidence, which I'm going to show your lordships. Paragraph 4 was put to Mrs. Ali. Her sister-in-law bragged about inside information and knew about the offer before I received it. Then 2 paras down, factual situation of the client and her sister-in-law had inside information. And the next para, I have to be mad to concoct the documents.
Mr. Strang,
Yes.
your client didn't produce any evidence, did he, about this inside information case of his? This was just put in cross-examination, am I right?
Yes.
So your criticism isn't so much that, as I understand it, the committee didn't deal properly with his evidential case, but that they didn't describe everything that he put in cross-examination to an opposing witness.
Well, he did say in chief that he did say in chief give a similar account to what he's given there, but it's not just about the evidence that it's not just about the cross-examination that he put the case he put in cross-examination to Mrs. Ali, but it's also about the answers that the respondent gave that in some measure corroborated Mr. Hosein's belief that Mrs. Ali and her sister-in-law did have another source of information about Guardian's offers. If we look at the background briefly, page 57 is where this is Mrs. Ali's evidence in chief, and here she's introducing her sister-in-law. It's the last paragraph on page 57. As Mrs. Ali's evidence came out, it was apparent that Mrs. Solomon advised her, accompanied her to meetings, and spoke to Mr. Hosein and the respondent on her behalf on occasions. And to introduce what the respondent said about this, I'm going to begin at page 166 with, this is Mr. Hosein's opening offer on behalf of Nazreen Ali, 25th of October 2010. And it was in response to that, the Guardian made the counter offer at page 172. And the handwritten note, page 1775, reveals that Mr Hosein didn't receive that letter of the 3rd of December until the 23rd, almost 3 weeks later. And in the meantime, in between that letter being sent and Mr Hosein receiving it, he said that Mrs Ali and Miss Solomon contacted him to tell him that an offer was on the way. And I've shown you what he said about that in summary in his oral submissions, 85. What he says about it in chief is at page 91. One, two, three, four. The 5th paragraph on the page. I recall the claimant and her sister-in-law calling prior to my receiving the counteroffer, saying I should have received the insurer's proposal. So in between it being sent and him receiving it, he says they called him to let him know that an offer was on the way. Now, we don't have a note of that particular factual issue being put to Miss Ali in cross-examination, although I've shown you where Mr Hosein summarised what he put in cross-examination. We do know that she denied, as at the 28th of January 2011, knowing what the offer was on that date. That's page 64, 2nd para. But it's in the respondent's evidence that there is some support for Mr Hosein's stated belief that his client and her sister-in-law had another source of knowledge. Because in cross-examination, he asked the respondent, did they contact you in December?
Sorry, which page is this, Mr.
And this is page 75.
Thank you.
This is the last question on page 75. And then over the page, the respondent says, yes, the sister-in-law called me sometime in December 2010. Told her I couldn't speak to her as her sister-in-law was representing. And then Mr Hosein goes through the timetable. You made the offer on the 23rd. I didn't get it until the 20th. So you made the offer on the 3rd. I didn't get it until the 23rd. And middle of the page, did Miss Solomon contact you after the 3rd of December? I can't recall. It would be between the 3rd and the 23rd. Yeah, it could be around the middle of December. So the point I'm making here is that this actually tallies with Mr Hosein's evidence that around the same time, Miss Solomon told him an offer was on the way. It shows, yes, my lady.
Is this a point you made to the Court of Appeal?
No.
So this whole issue has not been ventilated. We do not have their views on this point.
No, my lady. Yes, my Lord Stevens.
How does that fit with the practice of the board in relation to two concurrent findings of fact? It would put a coach of horses through it on one view, insofar as it would be an exception. You could turn up in the Privy Council and raise new issues that hadn't been considered below.
Well, my Lord, there's the question is whether in my submission, whether this is a point which reveals that the Disciplinary Committee did not understand a matter that was material to their assessment of the credibility of the two witnesses. As for how it was put in the Court of Appeal, as I said, in his written submissions, Mr Hosein emphasised the points that the Court of Appeal record him as making. On this particular point, the knowledge of Mrs. Ali and her sister-in-law, all I can say about putting this point is that he also, by way of a, I suppose, a catch-all in his written submissions, said, I also rely on the submissions I made below, which are set out in the notes of evidence. I'm just going to call up that to give your lordships the reference. Forgive me, because I'm just scrolling through the document which you don't have.
We do now have it. That's why I asked you my question.
It's just come in the last 5 minutes.
Oh, okay. I'm trying to find where he says that. Oh, yes. It's paragraph 8, page 8 of the PDF. So that's the most I can say about his submissions to the Court of Appeal.
So which set of submissions is it, Mr. Strain?
It's the appellant submissions. It's a 15-page PDF.
Yes, and it's page 8.
Page 8 of 15, paragraph 8.
Sorry, page 8.
Yes.
Paragraph.
Page. It's the very last paragraph of the page. It's paragraph 8.
Yes, got it. Thank you very much.
So, as I said, this evidence of the respondent does tally with Mr. Hosein's evidence that around the same time, Mrs. Ali and her sister-in-law told him an offer was on the way. And it does also give reason to believe that the sister-in-law or Miss Ali did tell the appellant an offer was on the way, or something along those lines, because he had reason to ask the respondent if they contacted her. Something caused him to ask the respondent if they'd contacted her. What it was the fact that they had told him that an offer was on the way. And in my submission, that's important. If Mr. Hosein believed that his client had another source of information about Guardian's offer, he couldn't have expected to deceive her, even if he'd wished to. And that would make the case against him much more improbable. Now, I've shown your lordships where Mr. Hosein made that point in his no case submissions. But there's no sign in its judgment that the committee was alive to that point. And in my submission, that suggests it didn't correctly understand the issues that were relevant to its assessment of Mr. Hosein's credibility. And that is a basis on which an appellate court can intervene. And in that regard, I rely on what Lord Mant said in the Central Bank of Ecuador case. And rather than give the board the full judgment, I've turned to Lord Mance's Privy Council practice textbook and the passage, the section on reviewing factual findings. Your lordships have probably seen these paragraphs before. And they begin at page 113 of the Supplemental Authorities Bundle. And in particular, I'm looking at paragraph 5.50 at page 115. About the principles of restraint. They rest on the assumption that the judge has taken proper advantage of having heard and seen the witnesses, and has in that connection tested their evidence by reference to a correct understanding of the issues against the background of the material available and the inherent probabilities. And that's the principle I rely on to say that failure to consider this important evidence in Mr Hosein's defence is a ground on which the board can intervene and set aside the committee's finding of fact. And those are my submissions.
Thank you, Mr Strang. I don't know if there are any questions. Yes, my Lord Briggs has a question.
Mr. Strang, can you just help us? I'm not sure I quite understood what has been your client's practice position during the pendency of these proceedings of appeals. As I understand it, the Disciplinary Committee didn't consider that it had the requisite powers. What then happened?
So nobody's exercised the powers to strike him off. He's remained in practice.
So he's remained in practice throughout and has practiced?
Yes.
Yes, thank you.
And Mr Strang, what order are you asking us to make?
To set aside the committee's findings, given that I'm submitting that there's a public interest in an accurate decision, I think I'm bound to submit that there have to be a further trial of the complaint against Mr Hosein, except that 10 years on is going to be harder to achieve an accurate decision than it was 10 years ago. But I submit it follows from the setting aside of the findings.
Yes, thank you. I don't think there are any further questions. No. We're grateful, Mr Strang, to you
Thank you,
for
my
your
lord.
submissions. We're grateful to those instructing you for the preparation of the case. We will take time to consider our decision. The court is now adjourned. Thank you very much.